introducing some of my colleagues. Where's Derek Cohen? I could have sworn I saw it. There's Derek Cohen, is my colleague in the Center for Effective Justice here at TPPF. I also want to introduce the director of our center, Mark Levin, although I don't see him in the room. Mark is so active, he could be anywhere. We're here working on criminal justice issues at TPPF because of Mark and his terrific vision. So I always like to recognize him. And those of you who work in the legislature, for the next few months, if you have any questions about criminal justice policy, find me, find Mark, find Derek. We can't wait to talk to you. Today, we're going to talk a little bit about overcriminalization. And it's an issue that we do a lot of work on at TPPF, and we do a lot of work on this issue, I say, thinking a lot about economic consequences. We think of overcriminalization as kind of a burden on economic opportunity, sometimes for ex-offenders who can't get occupational licenses to go and perform a job. We think about how things like that affect long-term economic growth here in the state of Texas. It has never quite occurred to me that overcriminalization could be thought of as a life and death issue. But I will tell all of you that in the last few months, I have started to think about it a little bit from that perspective. There was a very significant news story that everybody in this room is familiar with. Eric Garner in New York City was selling individual cigarettes rather than selling them in packs. And this is a crime in New York. It led to a very serious altercation with the police. Mr. Garner died, as we all know. And this has sparked, of course, a national conversation about policing. I think that's a valuable conversation. I also think, though, that we should be having a national conversation about overcriminalization. I think that it's just an absolute tragedy that this man died as a result of a chain of events that began with the fact that New York has made this a crime in order to comply with a tax, which perhaps we ought to be questioning also. So I hope today will be a part of that conversation. We're going to talk about unnecessary criminal laws. We're going to talk about the need for mens rea requirements. We're going to talk about how to apply things like the rule of lenity. We're going to talk about possible bills in the upcoming legislative session. We're going to talk about why we have overcriminalization as a problem. And I'm very excited about today's conversation and today's four speakers. So let me go ahead and get started by introducing our first speaker, who is John Malcolm. He is the director of the Edwin Meese III Center for Legal and Judicial Studies at the Heritage Foundation. He worked for 10 years at the United States Department of Justice. He was the executive vice president and director of worldwide anti-piracy operations for the Motion Picture Association of America between 2004 and 2009. John graduated with honors from Columbia and from Harvard Law School. John?
Great. Thank you. If it's okay with all of you, I'm somewhat walking wounded. I had leg surgery recently, so rather than take my crutches and hobble up there, I think I'll address you from here, since I've got a good view of all of you. Well, thank you, Vikrant. I'm delighted to have been invited here. And in the few minutes that I have with you, I've been asked to describe the phenomenon of overcriminalization, which is a problem in every state, by the way, and also nationally. Texas, of course, as you all know, has been a leader when it comes to criminal sentencing reform, making sure that your prison cells are occupied by the people who pose the greatest threat to public safety, and that alternatives to incarceration are at least considered for those who have done wrong, but whose lives are clearly redeemable and who pose less of a threat to public safety. And as you've done with respect to sentencing reform, I applaud the fact that you are now going to be taking a look and hopefully taking some affirmative steps to address overcriminalization. So in a nutshell, overcriminalization is the misuse, overuse, and abuse of criminal laws to address societal problems. Although overcriminalization in its classic and worst form involves criminalizing conduct that is not inherently morally blameworthy, overcriminalization actually takes many different forms. It occurs, for instance, when federal or state lawmakers adopt vague, overbroad, or duplicative statutes that carry criminal penalties for violations. It occurs when federal or state policymakers enact criminal statutes that lack any meaningful mens rea, that is, a criminal intent requirement. It occurs when federal or state lawmakers expand criminal laws into areas that would best and more appropriately be dealt with in the civil justice system or perhaps administratively. It occurs whenever federal or state policymakers create penalties that are unrelated to the wrongfulness of the underlying crime or disproportionate to any harm that is caused by the commission of those criminal acts. And it occurs when federal lawmakers federalize crimes that are best left to the states, which, after all, unlike Congress, has the constitutional authority. They have police power under our Constitution to protect the safety, health, welfare, and morals of the citizens within their borders. When there is no unique federal interest or expertise, and especially when there are state criminal laws that already exist that cover certain conduct, there's absolutely no reason to create a new federal crime. And doing otherwise is not only wrong from a constitutional standpoint, but it wastes very scarce federal resources and also can create a problem with respect to accountability in terms of who bears primary responsibility, the feds or state law enforcement authorities, to address criminal conduct. Let me talk about one other aspect of overcriminalization. So the Roman Emperor Caligula was infamous for all sorts of reasons. One of the reasons why Caligula was an infamous emperor is that he used to have laws written by his scribes in very fine print on tablets or placards that were posted at the very tops of columns. So those laws existed, and people would be held accountable for those laws, but they were, for all intents and purposes and in a very real way, inaccessible to the general public. Well, there are now so many laws scattered throughout the United States Code and the Code of Federal Regulations and in state and local code books that they end up effectively being inaccessible to members of the general public. So, for instance, it's estimated, it's rather shocking. Actually, nobody knows for sure what it is that I'm about to tell you, that there are now approximately 5,000 federal statutes and well over 300,000 federal regulations that carry criminal penalties for violations. And there are more being promulgated all the time, and that's just at the federal level. There's an old legal maxim that everybody knows, even non-lawyers, and that's that ignorance of the law is no excuse. That's a dirty trick, because the fact of the matter is that we are all ignorant. Nobody knows all these laws, or even a significant fraction of these laws. Now, mind you, this wouldn't be such a big problem if these criminal laws and regulations would cover conduct that was widely acknowledged as being morally or inherently blameworthy. So if the criminal laws were therefore murder or rape or arson or assault or fraud, that's conduct that every reasonable person knows is blameworthy. So the fact that there's a criminal statute that also covers that should come as a shock to nobody. And if you were somebody who didn't know that, it could clearly be said, well, ignorance of the law is no excuse. This was morally blameworthy. Every reasonable person knows this, so you shouldn't be shocked to figure out that there's a criminal law that applies to that. But that is certainly not the situation that we face today. Today, criminal laws and regulations touch nearly every aspect of our lives. The food we eat, the property we own, how we run our businesses, and all sorts of routine activities. And every single one of these new laws gives prosecutors more power. Many of these laws, as I said, are vague or overbroad, or as I mentioned, lack any kind of an adequate mens rea requirement. In other words, a lot of these criminal offenses, for a lot of them, a prosecutor just has to prove that you did some action that caused a particular harm. Could be an accident, doesn't matter. You would still be prosecutable and could be convicted even if you didn't know such a law existed, and even if you had no intent whatsoever to violate the law or to cause any harm. Some of these criminal laws have the opposite problem, in that there are some criminal regulations that are so hyper-technical that you need to have an advanced degree of some kind in order to understand them. The fact of the matter is that if a prosecutor were to look hard enough, that person would likely discover that we're all criminals, every single one of us, whether or not we know it, and regardless of whether we had any intent to violate the law. Some of these so-called crimes, by the way, came into being because well-heeled and well-established companies have hired lobbyists to pressure legislators and regulators to pass laws and promulgate regulations that literally criminalize the conduct of their would-be competitors. You see this a lot, for instance, in states that make it a crime for people or entities to practice certain professions or engage in certain practices without a license. Now, there are some professions, like being a doctor or being a lawyer, where licensing regimes make perfect sense because there's a great interest in protecting the public safety. However, there are a lot of states that have licensing regimes that cover barbers and cosmetologists and tour guides and funeral home directors with criminal penalties attached for violations. These kinds of overreaching laws are all about protecting entrenched interests and stifling competition, and they have nothing to do with protecting public safety. Do you really think it's necessary to prosecute an unlicensed barber and to send that person to jail? That is ridiculous. The end result of all of this, of all of these laws, is that they end up proving to be traps for the unwary. And people end up getting prosecuted and branded as criminals with all the collateral consequences that are attendant with that. Vikrant referred to a few of them, all for engaging in ordinary conduct that a reasonable person wouldn't even have known was wrong, much less a crime. That is just plain wrong, and it undermines respect for our criminal justice system. Now again, I understand that your legislature is going to be taking a hard look at the criminal laws here and procedures in Texas. I applaud that effort. I'm delighted to be here. I look forward to answering your questions, and anything that I can do to assist in that effort, I'm happy to do. Thank you.
Thanks, John. Our next speaker is State Representative Jeff Leach. He's the House Representative for District 67, which I believe is up in Collin County. Jeff serves on the House Committee on Criminal Jurisprudence, Urban Affairs, and Rules and Resolutions. He was recognized by the Texas Conservative Roundtable as the, quote, Lone Star Conservative, and by the Texas Eagle Forum as the top-rated conservative in the Texas House. He graduated with his undergraduate degree from Baylor, and he graduated with his law degree from Southern Methodist University, where he was a classmate of mine in law school. So it was a real honor to introduce him. Whatever you want to do.
I started at
Can you hear me here? And y'all hear okay? All right. Well, I'm just going to stay seated, John, and follow your lead. It's great to be here today. I want to thank Vikrant and the team at TPPF for just putting on a tremendous policy orientation. You always do, but this year has been extra special, and it's an honor to be on this panel with my friend John and Shannon and my colleague, Representative Moody. I see some of my other colleagues out there as well. I see Representative Steve Toth, who served with us on the House Committee on Criminal Jurisprudence, and then Senator-elect Bob Hall is here as well. I don't see any other members. If I missed you, I apologize, but I appreciate you guys being here as well. It really is an honor to be on this panel, and we're going to have a good discussion today and look forward to your questions as well. And I want to give you sort of my background, and in full disclosure, let you know that I'm coming from this in somewhat of a unique position as a lawmaker, but also as a lawyer. So I just finished my first term in the Texas House, going into my second term starting next week. I practice civil commercial litigation, business law. I'm primarily a construction and real estate attorney. I practice with the firm of Gray, Reed & McGraw in Dallas. We also have an office in Houston. So last session I came in and I asked the speaker, requested to be on civil jurisprudence and judiciary, and he put me on criminal jurisprudence. And so I had to quickly dust off my first year criminal law books and my bar exam materials and relearn the basics of criminal law. But let me tell you what a tremendous honor and a blessing it was to serve on the Criminal Jurisprudence Committee. We dealt with some tremendously important, heavy issues last session. We had a great committee. We worked hand in hand with prosecutors and defense attorneys to ensure that we were being not just tough on crime, but smart on crime in Texas. And overcriminalization is certainly one of the areas that we focused on and have focused on in the interim very heavily, and I think that is going to be a focus of ours going into the next session as well. At least I hope it will. And so And we're going to have an enlightening discussion today. So John talked about overcriminalization from a broad perspective and touched on some of the federal issues and things that he sees nationwide. And I want to talk to you about where we are in the state of Texas. Texas has roughly 1,700 criminal offenses in our code. Approximately, so 1,700 total. 1,500 of those, over 1,500 of those, are outside of the Penal Code and the Controlled Substances Act. Let that sink in. So the vast majority of the crimes that we have on our books in Texas are outside of our state penal code and the Controlled Substances Act. Often, these offenses are Class C misdemeanors, but there are also Class B and Class A misdemeanors, and I think Shannon is going to cover some of that in more detail in his presentation. Many of these occupational crimes aren't even necessarily crimes. So how does that happen procedurally? How does that happen in the state legislature? I was shocked to learn that was the case. Many of the bills we heard in criminal jurisprudence sought to enhance penalties, but also create new penalties. And we were challenged with the balancing act of how do you ensure that you're being tough on crime, that you're being smart on crime, but also how do you ensure that you're protecting freedom, that you're limiting the size and scope of government. I know we conservatives like to talk a lot about limiting the size and scope of government, and typically that involves lower taxes and less spending, but that also involves less intrusion into your life, into your family, into the practice of your religion and the operation of your business. And we learned that in the criminal justice perspective, that we can truly limit the size and scope of government overreach in the criminal perspective by attacking, in some instances attacking with a bomb, and in some instances taking a scalpel to our codes and finding crimes outside of the penal codes that we could possibly do away with that aren't necessary. Let me tell you, it's a problem in Texas when judges, prosecutors, defense attorneys, lawyers, and most importantly, lawmakers don't know certain crimes exist in our codes. That's a problem, and we found that to be true in our jurisprudence committee, and we found that to be true in other committees as well, which we'll get into a bit later. Our bill, in the 83rd legislative session, last session in 2013, our committee, which Representative Moody and Representative Toth and I sat on together, we heard the most bills in our committee of any other committee in the Texas House. To give you an indication, the Public Education Committee, we all think public education is pretty important in Texas, at least I hope you do. They heard 177 bills in their committee. The Ways and Means Committee, we all think taxation is pretty important as well, right? They heard 210 bills. The Criminal Jurisprudence Committee heard 254 bills last session, most of which either created new penalties or escalated existing penalties. And so that gives you sort of an indication of lawmakers. Shannon, I'm going to use a nice word. You may use a little a more honest word, but lawmakers' excitement to create all these crimes, the desire to create all these crimes outside of the penal code. And most often, these crimes come from one-time offenses. Something that may happen in the state, in some part of the state, West Texas, the Metroplex, it doesn't matter where, but something may happen, and they go to their lawmaker, and they say this is a problem that needs to be fixed, and so the lawmaker writes a bill that addresses the problem, but they do so by creating a crime. Let me give you a few instances. It is illegal in Texas, it's a misdemeanor punishable by up to 2 years in a county jail and or a fine not to exceed $5,000 to sell for a barber inspector to sell barber supplies. Okay? And what happened there was a barber inspector walked in, a state certified barber inspector walked into a barber shop, inspected the shop, and it didn't meet inspection requirements. And they told the barbershop owner, you're not meeting inspection. Oh, by the way, I've got the supplies in my truck outside that will help you pass inspection. And so that may be a problem, maybe something that the legislature would want to address, but do we really want to address it by creating a crime punishable by up to 2 years in a county jail? It's also a Class C misdemeanor to practice interior design without a license. Is that something we really want to criminalize in Texas? It is a third-degree felony for an athletic agent to give a gift to a collegiate athlete. Now, we can all agree, I think, that collegiate athletes shouldn't be receiving gifts under certain circumstances, but isn't that something that the NCAA and the schools ought to deal with? Should we really be punishing that by creating crimes? In my opinion, in that instance and in the other instances as well, the the criminal codes are often unnecessary and duplicative. So what we're here to talk today about is not just problems, but proposed solutions. Where do we go going forward? Where do I see the state going specifically in the next legislative session? We, like I mentioned, addressed this not only in the last session, but also in the interim. In our committee, we talked about, for instance, the rule of lenity. The rule of lenity would essentially, the tie goes to the defendant. In the rule of lenity situation, there was a bill filed by Representative Workman last session. I know TPPF has supported the rule of lenity, or at least has advocated for it via publication in the past. And I don't know whether that bill will be filed again this session, but I think it's an important discussion. There's some other proposals as well, and we considered that in the interim. We had a committee hearing in the interim on it, and our committee report, which just came out yesterday, our interim report says that we think we ought to further study the rule of lenity in Texas, and I think we will do so. What are some other things that we could possibly do? Well, we could start by not passing any new criminal laws. We could convince the legislature in the House and in the Senate that we ought to slow down the rush to pass new criminal laws, especially those outside of the penal code. If something is immoral, or if something is dangerous, or if something is hazardous, it's probably already a crime. And if not, if there's something that we need to take into account that's immoral, dangerous, or hazardous, then we can take that into account in our committee, not in other committees, which is something I'm going to get to in a second as I wrap up. We can create a commission to investigate, to actually go through our state code to find these duplicative, unnecessary criminal laws in other parts of the code, which we haven't done that yet, but I think that's actually something that we should strongly consider this next session, is to create a commission that's charged with going out, finding these crimes in other codes, and figuring out a way, if we can eliminate them, to eliminate them, or to create civil penalties or administrative penalties to take care of the problem in another way than just creating crimes. We can allow a mistake of law defense, basically a reasonable person standard. No reasonable person would have thought it was a crime. To my good friend John's point, there's a lot of things that we do, all of us, on a daily basis that we otherwise might not know are crimes. We have ignorance of the law defense, but that's really not a true or a fair defense, I should say, especially, like I said, when even the judges and the prosecutors and the defense attorneys and us lawmakers don't even know about them. How can we expect a reasonable person to know about it as well? And then something that I'm working on for this next session that I wanted to mention, and I'm going to pass it off to Representative Moody, is a House rule change. One of the things we're seeing is legislators who want to rush to create new crimes, and they file a bill that creates a new criminal penalty, and it goes to some other committee other than criminal jurisprudence. It passes through that committee, and then it comes to the full body of the House, and the House members vote on it without really knowing that it creates a crime. I know that shocks you to know that not every lawmaker reads every bill, but we have lawmakers that are voting on bills on the House floor that are creating crimes without knowing about it. And that's a problem that I think we ought to address. And so one of the things that I'm going to be doing is proposing a House rule change that will require that at the caption, at the very top of every single bill that reaches the House floor, if it creates or escalates a penalty, we're going to put that at the very top of the bill so that lawmakers who only want to read the first lines of bills know about it. That's really all I had to say. I know I probably talked for, I think I have, 7 seconds left. So it's an honor to be here today. Appreciate all of you being here, and I look forward to the discussion. So thank you.
Our next speaker is Representative Joe Moody. He's joining us today from House District 78, which is in El Paso. He served on the Criminal Jurisprudence Committee, the Committee on Border and Intergovernmental Affairs, and on the Defense and Veterans Affairs Committee. He is focused on criminal justice issues like domestic violence, smart on crime initiatives, and various efficiency measures that are designed to make the most of our limited criminal justice resources. He brings a very unique perspective to this issue, I think, because he actually served as a prosecutor for years in the El Paso County District Attorney's Office. Ladies and gentlemen, Joe Moody.
Thank you. I'm the token Democrat on this panel, so I appreciate Vikrant, I appreciate you inviting me. This is an important topic, and I really do. I'm very grateful for the organization here to engage in this conversation and this topic because, my educational background, I studied history, and then I went on to law school. I made that same mistake that Mr. Leach made when he became a lawyer. So I study history, and when you study cultures from our past, you look at you look at a lot of the criminal sanctions that they had in their culture, in their society, and we use that as a way to see what kind of a way to peek into their culture and what they valued, what their principles were, what their philosophy was. Since the time of the Code of Hammurabi, we've been trying to really figure out how to write effective criminal codes and what needs to be sanctioned and what doesn't need to be sanctioned. So those are the types of things you study when you look into, when you're in those history courses. And so I thought about Texas and some of the statistics that Representative Leach brought up about how many things that are in our code. If someone was looking at this society and this culture centuries down the road, and they're looking at our Barber crimes and our interior decorator crimes and all this other stuff that gets kind of lobbed in there, what does that say about who we are? What does that say about our philosophy, our culture? It says that our default was to make something a crime, and I think that's really an easy way out. I think for legislators, that's an easy solution. And the issue that Representative Leach brought up is exactly the point, and I'm going to end up repeating a lot of what he just said. I think he was looking at my notes. But when I came here in 2009, as a former prosecutor, I had an idea of what I wanted to work on. I wanted to work on victims' rights. I wanted to strengthen laws pertaining to domestic violence. There's definitely some issues related to gang interdiction that I wanted to work on. And then you started seeing the situations that Representative Leach talked about. Something happened in Beeville, and it was a horrible situation. And whatever it is, the representative shows up in the committee. They've written a bill now. They're going to make this illegal across the state of Texas, whatever the situation may be. And it's a very compelling story. You hear from the one person that was victimized by whatever the situation was, and they're telling you how it wrecked their life as a victim of this situation. And then they say, but I couldn't do anything about it because the police wouldn't prosecute, the police wouldn't investigate, DAs wouldn't prosecute because it wasn't against the law. We need to create a new law. And it happened over and over and over and over and over. And that's why we are where we are today. Because you have a compelling story, and you also have the situation that probably, in all honesty, is not going to occur again. And also is maybe a situation that if we look at our resources now, our tools as prosecutors, and speaking with that hat on, you need to look at what you have available today. My guess is if you feel that someone is really running afoul of your morals and values, there is something in our code that you can utilize today without adding something new. You can utilize something today to find justice in that situation. And that's really the guiding principle for prosecutors, is to seek justice and ensure that it is done in a situation. That means many things in many different situations. But I think a lot of times, the easy solution is, let's make that a new crime. Let's create an enhancement. Let's do this. Let's do that. And that, in the long term, creates a real convoluted mess. I know Representative Toth is back there, and he worked on, I believe he worked on the bill that you were referencing last session. I think that's a great idea to kind of clean up some of these things that have found their way into the code that maybe we don't utilize. I imagine most of these laws aren't being used. So why are they there? That's the kind of thing we need to have someone that's looking over that in a systematic way as we go forward. Structural changes to the system are important too, and Representative Leach talked about rule changes. And this is something that we talked about a lot during the interim. What do we do to slow this down? Because you're going to hear from Shannon from TDCAA in a second, and he's going to tell you that prosecutors from around the state of Texas propose all of probably 3 bills every session. 3 bills that their members, I don't even know it's 3, but their members have told them they need a fix in the law for X, Y, or Z. So where are these 254 bills coming from? If it's not our frontline law enforcement, where are they coming from? It's coming from those scenarios that I talked about before. So we need to look at changing the way we do things. Unfortunately, the Criminal Jurisprudence Committee historically is one that is a junior committee. I'm very grateful to serve on it, and I'm grateful to have people like Representative Leach, like Representative Toth that served last session on the committee, because they took a very serious look at the issue that we were dealing with. And when I talk about philosophy and who we are as a society, you have to look at it through that prism. And unfortunately, I think there's been people in the past that they're sitting on a committee that they consider a junior committee. They have no legal background. They don't care to get engaged in the issue. And someone comes up with a story that sounds pretty tragic, and they go, "Oh, sounds good to me. 3rd-degree felony, 2nd-degree felony, enhancement, new crime." Everything just moves on. So what do you do to really? You need to have people on the committee that care about the issues, that are willing to take the time, because it takes a lot of time to delve into these things. And building that institutional knowledge is important going forward. So I hope Representative Leach might be thinking about going back there and working on some of these issues with me. But some of the things he talked about, rule changes. So including that in the caption is absolutely essential. That's being proposed already. Putting it in a bill analysis so that when members and staffers are reading through bills, in the bill analysis, we're looking at, does it create a new crime? And this is some proposals that are out there today. Does it create a new crime? Does it enhance a penalty? Does it change someone's eligibility for parole? Does it change someone's eligibility for community supervision? Those are the types of things that need to be included in the bill analysis. And I asked the parliamentarian to go one step further and say, if it is not in the bill analysis, that is a sustainable point of order on that bill. Because those are the things that need to be there so members know what they're doing. Create institutional controls so we don't just keep lobbing things into the code. So in the caption is one thing. In the bill analysis is another thing. The third one that we proposed this session is not allowing anything that does those things I just mentioned to go to local and consent calendar. These things should go to the general calendar, not through a calendar that if anyone in this room has watched the local and consent calendar, things move rather rapidly. And I think it's a little bit frightening if you don't know this process and you watch it and you go, oh, taxing entity was just created. Oh, new crime was just committed. Or next new crime was just Freudian slip, probably. New crime was just created. That's not a wise way to create criminal justice policy. And so I don't think it's not really about limiting jurisdiction for that committee. It's about treating these types of bills with the seriousness that they deserve. And so those are the three proposals to create institutional controls to stop some of this stuff. Not necessarily to stop some of it, but to get people to pause and think about what they're doing when they're filing these bills. Because there are serious, we had a very serious bill last session that led to, 15, 17 hours of committee conversation. But it dealt with capital felonies. And it deserved that time and that attention and that focus. And it led to other questions about how we're going to treat 17-year-olds in our criminal justice system. So, it's hard to dictate how serious people will take things on a committee. I hope that you, and I know that Vikrant and everybody with TPPF tries to inform members on the committee, tries to engage them and let them know about the impact of these bills. That's something that needs to continue and focus, and please keep that pressure up. We need to hold folks to a pretty high standard when it comes to these types of, these pieces of legislation. Give you an idea about how ready we are to criminalize things. I filed a bill recently to create a civil sanction rather than a criminal sanction for 1 ounce or less possession of marijuana. When we asked the Legislative Council to draft something that would do that, they didn't know really how to do it. Why? Because we don't have civil sanctions for anything in Texas. Everything we do is a crime. So if you from their smallest class C and whatever you want to consider it, it is a crime. So we had to almost create it out of whole cloth. The red light camera violations were the only thing that was even somewhat similar. And so, that shows you that structurally maybe we're not even thinking in that way. And so I think the discussion on that bill is going to lead to a discussion about maybe we need to move things to a civil, into the civil jurisprudence system, so it doesn't carry with it those collateral consequences, so it doesn't carry with it that criminal history. I'm not saying that some of these situations aren't serious, but maybe we just need to change the tack we take, the approach we take to ferret out certain types of activity. We need to be thinking about those things, but up until this session, it didn't really exist. So those types of conversations are important to have. So I want to thank you all. I look forward to the questions and comments here today.
Our final speaker today is Shannon Edmonds. He's the Director of Governmental Relations for the Texas District and County Attorneys Association. He has written articles and made several presentations on the legislative process, on capital punishment, on prosecutorial ethics, on DWI law, on child abuse, on gambling, and on mental health issues. He received his undergraduate and his law degree from the University of Texas. Welcome, horns. Shannon.
It's okay, I got my notes down. Yes. Okay, let's see if these fun visual aids work. We were having a little technical difficulty beforehand. I want to thank Vikrant and the TPPF crew for inviting me once again. It's a topic that I enjoy speaking of. I will include this disclaimer that what I say here are my own thoughts and opinions and do not necessarily reflect the positions, opinions, or thoughts of any elected members of our association. That makes it more entertaining for you because I can say what I really think. For instance, we're talking about overcriminalization, which is an addiction in the state capitol. It really is. And the problem is that it's so easy to do, and you've heard many of the reasons for that. So what's the problem? Let me quantify it for you. In the last 5 sessions, how many new crimes do you think the Texas legislature has committed out of whole cloth? Now, if you've been in this talk before, don't raise your hand. I don't want to take questions. You want to raise your hand, take a guess. Last 5 sessions, yes, sir. How much?
D.
121. D. Okay. Anybody agree with D? Show of hands. Does that sound accurate? How many think it's less than 121? Couple hands. More than 121? Yeah? Congratulations. You're right. The Texas legislature creates about 47 new crimes on average over the last 5 sessions. These are things that were not against the law previously, and they decided to make against the law. Now, this number does not include enhancing currently existing crimes. We track those as well. The legislature averages taking something that was already against the law and making it more against the law about 25 times every session. They do this. And as a result, you heard Representative Leach talk about where these laws go. We rewrote our penal code in 1994, and it even won an award from the Northwestern University Law Review as the best penal code in the country for simplicity, clarity, ease of understanding, and internal logic. Now, we've made a lot of changes to it. It now has about 225 crimes in the penal code. But where did all those other crimes go? Well, they went everywhere but the penal code or the Controlled Substances Act. We've got about 50 separate enumerated crimes in the Business and Commerce Code, about 40 in the Finance Code, and we have 175 crimes, give or take, in the Occupations Code. That's more than was in the Penal Code when it was rewritten in 1994. We now have more crimes in our Occupation Code. So, of course, the general result of that is, wow, that's really interesting, Shannon, but who cares? Right? Who cares? Doesn't affect me. Well, it does affect you. And this I'm going to call my Caligula slide now for John. Because as we've mentioned, look, just because you don't know it's not a crime doesn't mean you can't be prosecuted for it. All right? We know ignorance of the law is generally no excuse. And this is interesting. This is a good segue into, people ask me, well, why is TPPF so interested in this? And why has the right gotten interested in it? I was reading an article a couple months ago about the Cook brothers, and they've starting to get involved in criminal justice reform because they had a refinery down in Corpus Christi. And they got prosecuted by the feds, not a state entity, for some environmental crimes. And the litigation, civil, criminal, administrative, lasted for like a decade or more. And they ended up I think paying fines on one charge out of many that had been raised and had to pay several millions of dollars to settle that. But obviously, that's an example of the hyper-technical administrative state becoming a criminal tool, which it really probably wasn't originally meant to be. So that's one way that it can be a problem. Now, I know that Mr. Norquist spoke here this week. This is one of my all-time favorite quotes by anyone on any topic. And it's important in this talk because if you want to shrink government to the point where you can drag it into the bathroom and drown it in the bathtub, you cannot keep giving it more things to do. That does not compute. Okay, if you want to shrink government, you have to give government fewer things to do. And criminal justice is a government function. It's one of the core government functions, of course. So our folks are concerned when people talk about some shrinking of what they do, but in others, they're like, yeah, all these laws that we never asked for and we don't prosecute because they don't happen, knock yourself out. So why do all these things get passed? Well, we've talked a little bit about some of the reasons for new laws getting passed. One of them is the sensationalization of national stories that don't even happen in Texas, but lead to bills in Texas. Now, I do have prosecutors who want to make changes, and they say, well, Shannon, what do I need to do to get this bill passed? I've got data, I've got logic, I've got common sense on my side. And I tell them, tap the brakes there, buddy. That doesn't help at all. All you need is one good horror story. You need one good horror story that gets media attention, which then gets the attention of legislators who thrive on that. That's free campaign advertisement for them, all right? This slide, by the way, was after the Penn State Sandusky sex crime scandal up in Pennsylvania. And the Pennsylvania legislature ran and passed all these bills, many of them which were not even asked for or requested by law enforcement or public safety or child abuse advocates, because they had to be seen to be doing something, right? People come to prosecutors all the time and say, well, why do you prosecute that case? And they go, because I'm a prosecutor, I prosecute. Legislators, I have to tell my members, why are they passing all these bills? Because they're legislators. Many of them think my job is to legislate. And so you get solutions that are looking for problems oftentimes, or sledgehammers that are proposed as solutions to kill flies. So, what are some other reasons why this happens? Well, first of all, we are increasing the number of crimes because we're decreasing access to the civil justice system. And we're doing that in a variety of ways. First of all, we woefully underfund both justice systems. We probably need 2 or 3 times more courts than we currently have in order to handle properly, efficiently, and fairly the number of cases that go through them. But we don't fund them. We also, if you ever tried to go up against somebody you bought a product for who wronged you and you want to sue them, you don't get to go to court. You probably signed something that said you may have to go to mediation or arbitration first, which they set up, so they get to determine the playing field. In addition, this is going to make me real popular in this building, tort reform, okay? We have a crime that made it a felony, a state jail felony, to practice chiropractic while intoxicated. That's a felony in Texas. Now, I'm thinking that doesn't need to be a crime. It could probably be a lawsuit. But when you limit what people who have been wronged can get or do to make them whole, you're going to send them to the criminal justice system looking for crimes. And then, of course, it's expensive to sue somebody. But you know what? You know where there are free lawyers? Our members get looked at as free lawyers for everybody. So why should somebody have to go pay a private lawyer if they've been wronged when, gosh, you guys are free and you'll do whatever we make you do? Now, of course, we're not really free. Our members are paid for with tax dollars. But that's the way it's looked at. So when we talk about Mr. Moody, when we talk about a civil proceeding, okay, one of the issues in the bill is who is going to file those cases and prosecute them? Right? Us. And we're not going to get anything out of it, and it's not going to make our folks very happy. That is an unfunded mandate. And of course, you also have the rent-seeking behavior that John spoke about earlier. This is an example, and we'll talk about the Garner case, all right? There's been a lot of outrage that he suffered that, that he basically was killed because the cops were being too rough, enforcing something that shouldn't have been a crime to begin with. Well, guess who made it a crime? The legitimate business people selling cigarettes and paying taxes who didn't like being undercut and didn't like the competition from people selling them on the streets and not paying taxes. So they go to their legislators to protect themselves. And this happens in one of my favorite quotes from P.J. O'Rourke from the Parliament of Whores, which is, when buying and selling are legislated, the first thing to get bought and sold are legislators. All right? Because business goes to the people who they helped put in office and gets favors from them. And that is how we end up with a lot of this overcriminalization of business conduct. It's business versus business. May the best man win in the campaign contest. That's one of the many ways this happens. Last thing I'm going to touch on is the rule of lenity, because Vikrant asked me to. I mean, look, nobody really gets it, okay? We have a lot of statutory construction aids. Here is one of the statutes from our Co-Construction Act, which lists 7 different ways. You don't need to read it. All you need to know is that, is adding an 8th going to really make that much of a difference? I don't know. We already use it. In fact, it came up in the Tom DeLay prosecution, so it's already used in some criminal cases. I don't really think anybody cares unless, again, what do we need as legislature? We need horror stories. We don't need logic or talks about philosophy or the Federalist Papers. Let's hear people whose cases would have been changed if the rule of lenity was in effect, and then legislators will be better informed about whether or not they want to make that change. And with that, let's have some questions. Thank you.
Great cartoon.
Thanks, Shannon. It is time for Q&A, and because I'm the moderator, I get to ask the first question. And I'm going to ask this. Shannon was absolutely right that nobody understands the rule of lenity. So, John, can you explain it? Because I think it's very important. I think you explain it quite well.
Sure. The rule of lenity essentially says that if you have a vague law, or one that is capable of reasonable interpretations in a variety of ways, essentially the tie goes to the defendant. It is a matter of constitutional law, the rule of lenity, but courts rarely implement it. They bend over backwards to say that vague laws, such as, you can be prosecuted for a theft of honest services, which can mean anything to anybody, that they will bend over backwards to say, oh no, that's clear, or it's clearly applied in this circumstance. And codifying the rule of lenity is essentially a way of telling judges, no, this is really, really serious, and that if the person has a reasonable interpretation that would explain their conduct in a way so that it is not criminal, that person deserves to be exonerated. And another way of addressing this issue was actually what Representative Leach here talked about, which is a mistake of law defense. A mistake of law defense would essentially say that if I come into court and I say that I did not believe that my conduct was criminal, and can also establish that a reasonable person in my position wouldn't have believed that that conduct was criminal, I'm exonerated. The two are attempts to get at the same thing, which is essentially say that it is up to legislatures to draft tight laws and for prosecutors to prosecute laws that have clear boundaries, and that when those boundaries are vague, the people that operate in that gray zone should be not prosecuted and not convicted.
Does anyone else want to comment? Okay. Well, let's go to questions. Keener.
For the representatives on the proposed rules change, are you seeing any interest in that outside the committee membership between ours and D's, or is it kind of confined to y'all?
We are. To be honest with you, a lot of members don't understand it, didn't even know it was happening. So I think it's enlightening to them that we're bringing this up, shining a light in a dark place. And I think we could actually get it into the rules. I feel fairly confident. Go ahead.
Yeah, I was at a rules working group going on this morning. I stopped in there before coming over here. I think it's going to be rolled into the version that's offered on the floor. I don't think it'll be something that you got to fly it with an amendment. I think it'll be part of the. I know many members have talked to the parliamentarian's office about it and the need for it. I will tell you that the bill caption part and the bill analysis one, I think, have zero objection. There is a little bit of reticence about the general calendar requirement, thinking you might snag something that's a must. Maybe you might snag something that you don't intend to snag that needs to get through. My sense is, and I've never seen a case where there's a must-pass bill that the legislature can't find a way to do some type of contortion to get it passed. There's amendment process. You can, if it's a must-pass, I think you can find a way to do it. So I just don't see how that concern is real. But that's the only concern I've heard is about that part.
Yeah, and there's two other issues that we'll want to focus on as well. Is how do we work amendments on the House floor that seek to create a new crime or escalated penalty? How do we ensure that members are aware? If you've ever watched House debate on the House floor, most of the members aren't really paying attention to what's going on, and oftentimes it's easy to slip stuff in. Which is why you need to help us be paying attention. Yeah, and then also I think it would be good for us to consider a rule that would require that any new crime or escalation actually comes through the Criminal Jurisprudence Committee. We had members coming to us on the House floor last session asking about this deal that was going in the Ag Code, this new crime, and we didn't even know about it because we hadn't heard it in our committee. That's a problem that we ought to fix as well. Just require every bill that's got a new crime or escalation to be referred through the rules into our committee.
If I could touch on that just a second. So the House of Representatives this past week, actually, on the day in which all of the new congressmen were sworn in, had an amendment to their rules. So you would have a situation where if any law was going to create a penalty or enhance a penalty, it had to go to the House Judiciary Committee, but that if another committee was adding new conduct to an existing criminal law or regulation, they could do that without any kind of a referral to the House Judiciary Committee, which is why, for instance, you ended up having the Ag Committee making it a federal crime to attend a cockfighting event, which was already, by the way, a violation of the law in 49 states. And they just amended the rules so that if now new conduct is being added, the House Judiciary Committee can request a sequential referral to address exactly that kind of issue.
Another question. The gentleman right here in the sport coat.
Yesterday, Governor-elect Abbott specifically mentioned one thing he'd like to do is get rid of over 150 licensing laws. I know in Texas they've talked about doing that in the past, but you always have the problem of every interior decorator in the state shows up, talks about the safety of flaming curtains and all that. I guess the question is, do you guys have a resolution to get rid of them?
Yeah, I haven't. I've heard him talk about that, and I'm certainly in favor of taking a scalpel to it. I haven't read what he's proposed or seen the 150 licensing laws he wants to do away with, but I'm certainly open to it and look forward to the debate.
You can have civil, or if somebody gets a lousy malpractice job with their interior design, you have civil laws. You can have people who have licenses get their licenses yanked. There are administrative penalties, and by the way, there's a little something called Yelp that you can actually go online and look and see what other people who've had experiences with interior designers. There's a whole body of information out there. When you're talking about truly, if you're talking about a heart surgeon, different story. Interior designer, come on.
Yeah, I think the phrase that Representative Leach used was correct. You need to take a scalpel to that. There'd be some public safety issues that you definitely want to keep in mind, but I'm sure that we've probably overdone it in some arena or another. So that's something that kind of got to categorically look at them.
One other aspect of the regulatory issue where it bleeds over into criminal justice is you'll see a lot of these boards or oversight groups are seeking to have their own peace officers under their authority. So, for instance, a couple years ago, the legislature created dental board cops. I think they have a couple of officers that allow them to go, and I honestly don't know what they do, but they're in the Code of Criminal Procedure. They're peace officers, and every session you see some other groups or some other oversight boards that want to have their own investigative arm. I mean, these are guys who strap a piece on their leg and go out and knock on somebody's door and investigate them for administrative violations, I guess. I don't know what they do, but it always was a head scratcher to me, and that seems like another growth of government that doesn't really get much much focused analysis or interest at the legislature. Put some teeth in the laws.
I want to say something about that briefly. You know, I work a lot on these licensing issues, and I find myself in front of the committee in the House that looks at licensing, and there are all these bills that will propose to repeal a license, and I'm in the hearing room, and I promise you, the room is packed full. Who's it packed full with? People who already have the license. And they're all talking about how important it is to preserve the license because health and safety are on the line. Well, they want to preserve the license because the second it goes away, competition comes into their field and it cuts into their profits. It's a very difficult problem because it's hard to get Joe average consumer who's hurt by this into the hearing room that day. It's very easy to get all the people who have the licenses. So to the extent that people in this room can follow those issues, take an interest, make phone calls, and talk to people, I think those kinds of things would help. Another question, right here in the black coat.
I think part of the issue on the licensing is a question of what kind of technical issues are coming up and whether or not you've got expert witnesses who can explain that to you. A hairdresser. Everybody's saying, why do we license hairdressers? Well, my hairdresser is as old as I am, and when she became a hairdresser, she had to know chemistry, she had to know science, and because of that, she can dye my hair, she can do a lot of things that are really good for me, and she has young people who don't have the same requirements coming to her and saying, why did this woman's hair fall out because I did these stupid things? It doesn't need to be criminal, but you need to understand when there are real technical issues and when there are false technical issues. And science, legislators don't know anything about science, pardon me.
Don't get an argument from me.
You need good expert witnesses when there are real science issues involved.
I have no doubt that there are technical aspects to any number of professions, but with all due respect, I'm not sure that when your hairdresser got her license that level of education was necessary. It's a closed shop. Professions like it that way because it keeps up prices by limiting the supply of professionals who deliver that service. And the worst consequences are certainly something that can be dealt with easily at either the administrative level or the civil level. If you end up getting a bad hair job and your hair falls out or turns purple, it is certainly embarrassing. It is certainly bad. You have certainly suffered some kind of a harm. But to brand someone a felon for that, all in the names of stifling competition.
Let's go to another question.
Administrative is fine. I'm asking that the legislature consider science and technical issues appropriately so you know the level of risk. And if it's administrative, that the penalty fit issue.
Sure, you guys talk afterwards. John's not going anywhere because he has a bad foot. He can speak later. Let's go to Andy in the second row.
Can you explain the logic behind red light violation?
Oh,
Can you explain the logic behind red light violation? Caught by a policeman, that's a criminal offense. But for the exact same violation, caught by a camera, it's a civil offense. Can you explain why and how that happened?
You want me to do that? I'm not elected.
How much revenue does it get?
Yeah, I'll answer that because I'm not elected. It's about revenue. I mean, it also, on paper, it'd be great if it improved traffic safety. And there are studies on both sides. Some say it do. Some say that it may increase violations because of rear-end collisions and things like that. But ultimately, it's an opportunity for vendors to find a way to partner. One of these great, I always hear about public-private partnerships. Hey, red light cameras. There's one for you. But all of a sudden, everybody goes, no, we don't mean that one. One of the things that prosecutors don't like about them is that in many of those, there are provisions in there that say that the images taken can only be used for the purposes of the civil fine and cannot be used as evidence in a criminal case. So if we're chasing somebody or they're running from the cops or they get in a car accident, the law says we can't even use that in evidence in the criminal case, which is absurd. And that just goes to show you that it's all about a way to generate revenue on both sides, on that public and that private partnership. But the other reason is because we don't have enough officers to make sure those troubled intersections are safe. Because if you have one in your neighborhood, you want your local government to do something about it. All right, your kids are crossing the street, you almost got hit there, you want them, well, what are they going to do? Just park an officer there all day? That costs way more than contracting with someone to set up a camera and have hopefully a deterrent effect. So it's obviously trying to address a problem. Whether or not it has other unintended consequences is ripe for debate. That would be my take on it. Does that help answer your question? Somewhat.
Ebony, let's go to Christopher Burnett in the back there.
In terms of the occupational and regulatory side of things, I think it's important for folks in the legislature to understand also that there's another pernicious effect of all of this, and that is regulatory agencies and licensing agencies will take oftentimes those crimes that fall under their particular code or also a civil violation of their code, and therefore can be civilly acted upon by that agency in an administrative hearing. And so what will happen is that there may be a whole number of those things that are Class B, Class A, whatever the case may be, that regulatory agency, regardless of whether a district attorney wants to do anything with them or not, they'll allege those in their complaints and their notices of hearing and use that as a tool to get a settlement out of the licensee, whatever the case may be, in order to get the case to go away. And part of the thing they will tell them is that, well, if we go to hearing, all this stuff possibly could get used in a criminal prosecution. So that happens quite a bit with a number of agencies here in the state. So I just wanted to point that out to y'all. And I've got to admit, I'm a recovering administrative attorney who has done that very thing. But it happens a lot in the state.
That's a good point.
We wish you well in your recovery.
Any more questions? Ed Heimlich.
Yeah, I'd like to ask Mr. Malcolm if his organization's done any studies into the relationship between accountability or lack of accountability and the overcriminalization, over-incarceration. My studies have revealed that it started, we see the graphs and we see that the big increase started in the 70s and continued right up through present day. And that corresponds with the judge-made law coming down from our Supreme Court that actually did allow ignorance of the law to become an excuse if you're a police officer. They call it qualified immunity. And they also, in that same period, created absolute ignorance excuse for prosecutors. They have absolute immunity. And likewise for judges. And then the big daddy of them all is they took sovereignty from the people and gave it to the government. And you have government immunity, absent a waiver of suit and liability.
So Ed, I'm not understanding. The first thing is,
Yeah.
I'm wondering
So-
if there was a paper that Heritage has done that has found a linkage.
Throwing a
between
lot of
what-
stuff in there, so I'm not.
Yeah.
I'm sorry,
Yeah.
there's a lack of accountability.
Okay.
And that's why we have protests in the street across the country, because there's no accountability from those that accuse us of crimes, prosecute us of crimes that were not even committed.
But Ed, I'm sorry to cut you off, but we're friends, so I can do that. What's the question?
The question is, what about the relationship between accountability? That's not being addressed here. The lack of accountability for victims of crimes committed by government actors.
I'm still not quite sure where you're going because you referred to mass increases in incarceration in the 70s and 80s, and that certainly occurred. That has to do with a lot with, drug offenses and mandatory minimum penalties, and I don't think that has to do with any kind of. You were really referring to prosecutorial abuses or abuses by investigators. Look, the system is somewhat unbalanced. I think that may be true. On the other hand, you also have law enforcement officers, prosecutors who are out there, particularly law enforcement officers, who are in fast-breaking situations and trying to figure out what to do. And there are gray areas in the law, and under qualified immunity, if an area of law is clearly established, then the person doesn't get immunity if they've clearly violated somebody's rights, and they can be certainly sued civilly, and if they go far enough, they can be criminally prosecuted. Even for prosecutors, you want to give them enough breathing room to be able to investigate cases and not just prosecute cases in which there was a confession and 5 witnesses, 3 of whom were priests, 2 of whom were, one of whom was a rabbi and another of whom was an imam. They need to be able to go out and investigate matters in which the facts won't always be clear. However, if your point is, have the courts bent over backwards too far to immunize extreme exercises of bad judgment by law enforcement officers and prosecutors, maybe, but that's going to be sort of on a case-by-case basis.
We got to take one more question from Stacy Hawk. You can talk with John afterwards. Absolutely.
My point is this. A prosecutor has a duty to know that ex post facto law is a protection in our Constitution. And yet our governor is being prosecuted for exercising his right to veto.
Well, if you want to have if you want to talk about.
Prosecuted for his disregard for our Bill of Rights.
I have written about, and I commend you to read those articles about the Perry prosecution and why I think it is a ludicrous prosecution. I think suffice it to say that when you have people like David Axelrod, who's one of the major advisors to President Obama, who said, "Oh, perhaps there was some overreaching there," then that prosecution is on shaky ground. I have no idea, of course, what the court will do. And I'm not saying that there aren't egregious prosecutions. I think there are egregious prosecutions. I thought you were talking about then what is the remedy for those egregious prosecutions against either investigators who get qualified immunity, prosecutors who get absolute immunity, or against the state who has sovereign immunity. That is a very different story.
Shannon, you want to comment?
Since we're talking about studies, I will take a chance to refer people to our website. We did a study in 2012 and put out a report on prosecutorial misconduct, setting the record straight on prosecutorial misconduct, debunking a lot of the bad information that was out there about Texas specifically, and talking about all the different ways that prosecutors in the state are held accountable. And we name names and cite cases. There are over 100 footnotes to it with links. It's all been thoroughly researched, unlike the work that many of the people who are attacking our profession do. And the other thing I would add is I want to caution people who think that they see people protesting in the streets over the failure to indict somebody or over-indicting somebody, and especially people who represent folks in marginalized communities or the poor, and they think, well, if we could just go after the prosecutors to hold them more accountable, that would cure these problems. In reality, that's not going to help those people at all. The people it's going to help are the rich and the powerful, because they can afford to lawyer up and defend themselves by suing the prosecutor until the prosecutor, who for all their reputation is still getting a county budget, getting paid, is the poorest paid lawyer in the courtroom oftentimes when they come to court. And so the people with access to resources are the ones who will be able to litigate their way out of being prosecuted if you unwisely open up the immunity Pandora's box. So there are a lot of different things to think about in there, but go look for it on our website. Just Google prosecutorial misconduct. That report will come up, and I think you'll find it very informative.
1 minute, last question, Stacy Hawk.
Hi, I'm Stacy, and I just I'm happy to tell the four of you that I could stand up and applaud for all of your speeches. Mr. Edmonds, I wish all prosecutors were so entertaining. That was awesome. And for both, of our representatives up there, it's an exciting time when both sides of the aisle can be in violent agreement that we should scale back on regulatory overreach on the civil and criminal side. And it's not glamorous. And so thank you for all you do to make people aware of it and to look at things we can do procedurally to change the course. I think that there is natural motivation to legislate in new boundaries when egregious things happen. And so I love it when we have the opportunity to step back and maybe engage a commission to do a sweeping review, perhaps every 20 years is the right clip level, to look at the penal code and to continue to maintain what is a really respected and clear penal code. So thank you so much for what you're doing. I think my question was, as a layperson, how can we support your efforts in perhaps bringing glamour to this otherwise unglamorous role?
If you get accused of a crime of a penal code, let us know so we'll know as well. Thanks for your words, though. Just stay involved, and we appreciate your participation.
Yeah, you're active, and I probably don't need to instruct too heavily on that, but trying to engage folks. Keep an eye on the committee. Like I said, it is a junior committee. The education level on these topics is probably not high at the time the committee assignments are made. Keep an eye on that. Do your best to get folks from that district to reach out, make sure they're showing up to the meetings. We met till 3, 4, 5 in the morning many times. We competed with public education almost on a weekly basis on who let out last. And like you said, it's not the hot topic of the day usually, but it's the one that can take away someone's life or liberty.
Right.
And if we don't treat it with that level of seriousness, we're making a huge mistake. So I try to do that. I know Representative Leach does, and mentioned Steve Toth as well, did the same thing. So we need to do our part to educate those folks that get on that committee, because they may not want to be there. I'll be honest. There's people that check out. They don't want to be on that committee. Engage them. Make sure they know why it's important. Get in their district and make sure you get people calling them from. I know that's how I triage things. If you have people calling me from District 78, then that's top of my list. So that's the same thing to do with some of the other folks.
I just want to say, I know a number of you have got a copy of a booklet called USA versus You. It's a heritage publication, but joined by a lot of other groups discussing this issue in general. I'm not sure whether there are copies still floating around outside. If you did not get one and you want one, just please contact me at john.malcolm@heritage.org, and I'll be happy to send you one.
All right, this April, if it's Wednesday at 2 a.m., you have nothing to do, me and Shannon and Representative Moody and Leach will be in the hearing room. Come to Crimjur. Otherwise, right now, please join us in the ballroom where we're going to listen to Governor Perry, Newt Gingrich, and Stephen Moore.